salary as the business.
Good evening, everyone. Welcome to the special immigration show brought to you by Sakshi TV. My name is Ranjit. We are here today with the prominent attorney, Ms. Sheela Murthy, to discuss the latest updates followed by frequently asked questions. You can call the numbers displayed on the screen and ask any question related to immigration, and attorney will be glad to answer. We will start taking calls in few minutes. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions, so please use the information at your own risk. For case-specific issues or concerns, please reach out to the attorneys for a private consultation. Ms. Murthy, you all know Ms. Murthy is the founder, CEO, and president of Murthy Law Firm and Harvard Law School graduate. Also, she's the one behind the famous Murthy.com website. Before getting into the show, hi, Ms. Murthy. Could you please briefly introduce and then we could take it from there?
Thank you so much, Ranjit. Welcome, everybody. I know it's very late in India, of course, the afternoon, middle of the afternoon here in the East Coast of the United States. We're so honored to have you. As Ranjit just explained, Murthy.com has been providing immigration legal services through Murthy.com, Murthy Forum, where they have 150,000, 200,000 active participants monitored by attorneys, providing free information, is general guidance and rules. And then, of course, you have the weekly Murthy Bulletin. You can subscribe to it. It's free. It's a part of our service to educate, enlighten, and enrich you as immigrants going through the process. We also have the monthly conference calls to educate employers, which is available for everybody through the weekly Murthy Bulletin, where we provide the link. And of course, everything like the Sakshi TV weekly interview. And I think we're also starting a new 1-hour panel discussion starting from next month, particularly dealing with immigration topics, where I will be the moderator with a team of lawyers from the Murthy Law Firm. It is always our commitment to inspire, educate, empower you so that you do not feel alone along this long, complicated immigration law process. And there's so many changes happening on a daily basis. So questions and answers and trying to go over it, touching upon it will always be very helpful. Thank you for the opportunity.
Yes, Ms. Murthy. We already have a caller from Texas. Let's take the call. Hi, welcome to the show. Please go ahead and ask your question.
Hi, good afternoon. My name is Shekhar.
Hi, Shekhar.
Hi. I have 6 years max out. I'm on H-1B visa right now. So already my employer filed for perm processing. Right now, not yet updated any update on the perm processing application. So he said he's going to file a B1. So am I so what is the next step I can able to take to stay in the United States?
So obviously, Shekhar, it depends on your background, credentials, qualifications. If you have recaptured every single day that you were outside of the country, then what you could. I wasn't clear. You said the employer applied for the perm. If the perm was filed more than 365 days earlier, then you could apply for 1-year H-1B extensions of status. Obviously, after the perm is approved and the I-140 is approved, then you can get 3-year H-1 extensions of status. As long as the priority date is not current. So it's 1 year based on 365-day rule, or 3 years if the I-140 is approved and the priority date is not current. Options like B1, B2 could be okay, but again, it's not the ideal situation, because remember, when you're applying for a B1, which means I'm a temporary resident, I definitely plan to depart the United States as soon as my short-term temporary tourism purposes are satisfied. But you know that when you apply for a perm, that means you're planning to settle down or immigrate permanently into the United States. So technically, there is what's called a conflict of interest that happens, a conflict that is happening in your case, Shekhar. So B1, B2 is not the most ideal situation to stay here. It can give some temporary relief, but obviously you're not legally permitted to work, even check your emails. You're not supposed to perform any work that is considered a violation of both U.S. Department of Labor and USCIS regulations. So it's not the ideal situation. Sometimes it's even better for a person to be outside, because then you can try to recapture that time when you come back, especially if you get a Department of Labor audit on your perm, and that takes, if you're stuck after a year, you could still be without a salary and spending hard-earned money here. It may be sometimes, depending on the situation, really you need to discuss this with your lawyer. If you don't have a lawyer or don't feel confident that they can help you because they are focusing on the employer, then please contact murthy.com to schedule an appointment to go through and see if there is something else that might be better. Because ideally, I know now it's a horrible time to travel, especially to a country like India with COVID-19, and India has shut down the borders. But it's a catch-22 whether you want to just stay here, especially if the perm gets delayed and you lose your salary for many more months or even 1 or 2 years without a paycheck.
Thanks, Shekhar. Thanks for the call. We have another caller, Akash from Mumbai, India. Let's take the call. Hi, Akash. Welcome to the show. Please go ahead and ask your question.
Yeah, hello. Hello, madam. Actually, I don't know your name properly. So can you please tell your name?
Sheela Murthy.
Yeah. Hello, Sheela Murthy. Thank you for talking to me. Actually, my question to you is that I'm a international student who came to USA in fall 2019. Okay, so I came over here to do my master's. So I am currently on F1 visa. So I have the visa. I started my degree from fall 2019. But the thing is, my parents got severely ill, due to which I had to travel back to India on 28th of April. And as soon as I landed over there, on 30th April, I heard the news about travel ban. But the problem is that this summer is my last semester, and I want to come back as soon as possible because I want to continue my full-time search. Along with that, I want to file my OPT because I cannot do that while I'm in India. So these are my problems, and according to the rule that I read, it seems that they are allowing only after 1st August, and 1st August seems to be too late. So could you please help? What can I do? What other options do I have?
So a person, because you have been enrolled in the school and attending all of the classes, Akash, it sounds like you should be able to apply for the F1 OPT, and you are allowed to work for 12 full months on OPT. Even if you're not physically in the United States, you can apply for the F1 OPT. You're considered in F1 status. And from the day that they approve it, because Biden administration changed the rules, instead of making it for the so if it took them 6 months to approve it, you would only get 6 months optional practical training. But because the Biden administration tried to make it more fair, if they take 3 or 4 months to process your EAD or 6 months, you will actually get 1 full year of F1 OPT to work legally in the United States. So please apply for the F1 OPT. You can even do it online. As you know, the USCIS has just started this new process recently. The DSO, your designated school official or international student advisor, should be able to guide you with that, Akash. You don't have to be physically in the United States to apply for the OPT. And then when you get it, you can it'll take 3 or 4 or 5 months. You can then work as soon as it's approved and issued for you to work. I'm guessing you have an address in the United States that you can use for the purposes of the US Postal Service delivering the EAD card so you can work legally. So hopefully that should help you, Akash. And I'm so sorry to hear about your parents not feeling well. I hope and pray that they do better. And I know it's been very, very tough time for many, many people whose families are suffering. We pray for their healthy and speedy recovery.
Ms. Murthy, a follow-up question. Students not exempted yet from the ban? If they have a valid visa?
Yes. So the other thing is, of course, if he's got a valid visa that allows him to enter the United States, he is allowed, because students are considered in the emergency exception and exemption. You are generally permitted to travel in and out of the United States. Of course, I also know India itself has shut down, I think, the opportunity for flights to come in and out of the country. So that's the other potential risk, is if there are no flights, then obviously you can't come in. But students are generally exempt, as are people in the healthcare professionals, national interest exemption, doctors fighting COVID-19, but students are considered in the top set of people even eligible to apply for the visa at the consulate. But in Akash's case, if there is a visa stamp in the passport, you can certainly, if the flights are coming in, flying out of the out of the country into the United States, you should be granted permission to continue your education. But again, I don't know that you want to come in if you are able to complete the education and apply for the F1 OPT, because until you get the F1 OPT, you cannot start working legally anyway, right?
Yeah, true. I just wanted to, ask that if he had a valid visa, he can try and get in. That's the question. So we have another caller, Prashant from Texas. Hi, Prashant. Welcome to the show. Please go ahead and ask your question.
Yeah, hi. Thanks for taking my call. This is Prashant. So, the thing is, my mother-in-law, she's here on visitor visa, right? And then she got a valid visa till July, and her visa expires in July. But what we are looking is, are there any options where we can get extension or, extension of visa so that she can stay longer here instead of going back, Do you have any options, any suggestions, any solutions?
Yeah, Prashant, a lot of people are doing this, filing the B2 extension of status. You can do it by paper. You can do it online and upload all of the documents. As long as you can explain the risk of travel and why you're not comfortable to send them back. Right now they're requiring biometrics, but as you know, from May 17, they're put a hold, but it's only applicable for L2 and H4 and E3s. So B2s are still required to attend the biometric appointment, but you can apply for a 6-month extension. And that is very, very commonly, that is what many people are doing, so that because they don't want their parents or parents-in-law to go back at this very risky time with everything going on in India. Hope that is helpful.
Prashant, I hope that answered the question. Again, following up with the previous question, Ms. Murthy. So I know a lot of people, who came in last year or before that, have been extending the B1, B2 visas. So do you think there is any threat for them when they enter next time, because they have already stayed for over 6 months? Some people have stayed even over a year, and still the petitions are pending. So what are the complications do you think there would be next time they try to enter at the port of entry?
Yeah, we've talked about this in the last 2 or 3 weeks as well. It definitely can create complications for people if they travel, especially if they stay for so many months or even a year or two in the United States, year and a half at this point, because they're afraid or nervous to travel because of the COVID-19 pandemic. But the longer you stay, the more difficult it is to tell the CBP that, yes, I am only traveling as a tourist and plan to return back, because the longer you stay here, the more that comes into question. As long as you can explain it and show that you clearly have strong family and financial ties in your home country, it could work. The big risk, of course, is we have seen cases where they scheduled the biometrics, the people left the country, the case was denied, and based on the denial of the B2 extension, the CBP was given notification that the visa is automatically cancelled by operation of law. So the 10-year multiple entry visa becomes void, and then the person cannot use it to travel and re-enter back into the United States. If somebody has stayed here for a year and a half, you should not try to re-enter back anyway. At least ideally you want to wait 6 months, 1 year, 2 years, so that you don't raise a red flag. But if you come in, the risk is that your visa may have been voided or cancelled under 222G, Section 222G of the Immigration and Nationality Act, because of the denial of your B2 extension of status. Now, if you departed before the B2 denial happened, if you had departed the United States, your parents-in-law, then you need to keep proof of the airline ticket, the boarding card, the proof that of the departure, prove that the date of the denial of the B2 was after departure from the United States, so that you can next time argue when you try to re-enter United States that the B2 visa should not have become void by operation of law. But that is definitely a risk we are seeing, we are hearing about it. And also remember, tourist is not supposed to spend more than 2-3 weeks, 2-3 months, maximum 6 months in a 12-month period in the United States. Minute you cross over, they say, okay, clearly you do not have strong family and financial ties in your home country, because if you had to return, you wouldn't have been able to stay here for that long.
Thanks, Ms. Murthy. Thanks for your advice. Okay, we have, I believe we have a couple of updates. So could you please go with the updates and then we can ask some questions?
Okay, that would be great. So as many of you may be aware that people on H-1B, the Trump administration had changed the requirement so that the lottery registration system would be based on salary, whoever is getting the highest or the maximum amount of salary. The Biden administration just postponed that rule for about a year, till next year, till 2022, but they did not eliminate it because they are also very concerned about high unemployment in United States, COVID-19 pandemic, and millions of Americans are without a job. So what happened is yesterday, May 17th, 2021, American Immigration Lawyers Association, AILA, along with several businesses, filed a complaint against the Department of Homeland Security. It's called the Humane Society of New York et al. Versus Mayorkas, where they challenged and said that the Department of Homeland Security cannot come up with completely new criteria, pulling it out of the hat with no legal basis, nothing under the statute or regulations, to change the criteria for the registration system from pure random lottery-based system to one that is directly connected with how much salary the employer is paying the employee. So we don't know if it will succeed. We don't know what's going to happen, but that is something that has absolutely been filed by the by AILA and certain businesses against USCIS and Department of Homeland Security, telling them that they cannot use salary as the pure and the only basis or the main basis to pick H-1B lottery numbers for pre-registration or registration. So let's see where that comes. So that'll be an interesting update that's happening. Also, AILA, as I mentioned, USCIS is now allowing F1 OPT to be filed with the 539 online and with the 765. So USCIS is giving some trainings. The CIS Ombudsman is training students on how to complete that information and what information and documents to upload. And same thing with B1, B2s that we just talked about, Ranjit. People are allowed to file it online and they absolutely can provide and update all the information. And if that way, if you're short on time, you can get the receipt and the information, everything online. But then you have to check the online status on a very regular basis, because when there isn't a regular checkup or problem, we have seen that comes back to haunt the people.
Thanks, Ms. Murthy. Just a follow-up question. So you are saying that I-765 now can be filed online. That's only for OPT?
Yes, you can do I-765 with your I-539 if you need to extend your F1. But yes, it is now permissible for the 765 to file that for F1 OPT students, which before there were many more roadblocks, and they're trying to make the USCIS realizes that opening it up for online filings is much easier, but they are having a lot of technology and other issues that they have been dealing with for the last 15 years. You would think with the resources of the federal government, they would benefit, save time and money for applicants and for the government by setting up an online system for easy access to take checks and fill out the form. And that way you don't have the risk of getting lost, the package getting lost in the mail. But they have started, they are trying to expand more and more the number of forms and form types that they will accept for online filing.
Yeah, hopefully they do accept for the H4 EADs, L2 EADs, because I think it's almost pretty similar thing for like an OPT EAD as well. So that way, yes, people can file online and save a lot of time and money as well.
Absolutely. And it benefits the government, also saves a lot of money, right?
Yeah, a lot of paperwork.
Hassle, headache, because they need mailroom contractors to open the mail. They need so much time and money and cost that they have to spend to sort of delegate this work to outside contractors, which is costing us as taxpayers, which is why the legal fees goes on increasing all the time for processing, and the quality of service keeps on reducing all the time. As I often say, if you and I in private business did a business where the quality of work kept falling and the prices kept increasing, none of us would be able to stay in business.
True.
But that is the federal government, and they have a monopoly, and unfortunately they issue the visas and not us.
As well, with the current technology advancements, I believe USCS can make everything online because people are writing complex codes and artificial intelligence nowadays. And I don't think this USCS form is any more complicated.
It's a good point. In fact, a lot of times we have had our H1 workers joking, I'll volunteer and do it for free. I'll help the government. I'll, work on the forms. I'll work on with the coding. But then the complaint will be that you're taking away a job from a US worker who could get full salary and full payment for it. So you're damned if you do, damned if you don't. There's no easy solution, right?
Yeah, thanks, Ms. Murthy. We have another caller, Nayak from Texas. Hi, Nayak. Welcome to the show. Please go ahead and ask your question.
This is Nayak. Yeah, I have a question regarding the travel. So, due to the pandemic in India, there was H1B slots are getting cancelled. So, if I see the recent updates from the Indian embassy, so they are suggesting to stay if you are planning to travel to India. So they are suggesting to stay for longer. So if we are in H1B, so legally, how many months we can stay in India?
So it depends on the employer, Nayak. It depends upon whether they allow you to perform your work remotely from a foreign country. Generally, there is no H1B violation of H1B laws or regulations or immigration laws. I think we talked about this also in the last couple of weeks. Because you are allowed to work from anywhere in the world, and if the employer agrees to continue to pay you your full salary into your US bank account or into your Indian bank account or wherever, that is 100% legally not a problem. If you're a citizen of India, you have permission to work in India, you can go there and work and stay for weeks, months, even years. It's completely between you and the employer. But the only issue, of course, is taxation. If you work for very long periods of time abroad in India or whichever country you choose to work from, then you are required by law to pay taxes in that country and not pay withholding and other taxes under US tax laws. So that is the main issue that we have touched upon in prior discussions. So from an immigration law point of view, Nayak, if your family needs you, you need to go, you need to be there, then take advantage of it.
Hope that answered your question. One question a lot of people were asking these days, because of the travel ban and everything, a lot of people got stuck in India. And like you're saying about the OPT thing, they can still apply EAD when they are in India. They don't have to be in US because EAD is not a status, it's a work permit. So is the same applicable to H4 EAD and L2 EAD?
Generally, yes. You are, as long as you had the H4 status. The problem is you still have to show H4 status. So if the person had H4, let's say valid for 3 full years, and you're abroad, then yes. But if you don't have H4 status, you haven't entered, then you're not considered to be in H4 status. They made an exception for students because they did not want students, as if you remember 1 year back, the USCIS changed the policy and said that if you are attending purely only online classes, then you don't need to enter the country to continue, but you can maintain your F1 status. You're considered in F1 status. The school can issue the I-20, even if you're not physically entering the US. You're considered an F1 student if you're registered to study with a US university that has issued the I-20. The same rule does not apply for H4 and L2 because the law, they made an exception for students because US universities and the US economy is benefiting by billions and billions of dollars with students, international students paying very, very high international student fees because you don't get benefit of in-state tuition discounts, etc.
So if they were in US and they just went out, they couldn't apply. Plus, if they have never entered US, maybe that's complicated.
Correct. Correct. If they had an H4 status already approved, or they had come in, they have H4 that is valid now for 2 years, then absolutely take it and try that, because you're allowed. We have done that for 485 EADs as well for people.
So if they have stamp, let's say if they have an H4 stamp, but they have never entered US, but can they still try?
So the USCIS will probably say, how can we give you H4 EAD if you're not on H4 status? Because you have to enter the US at least once and then show your I-94 card. So legally that is not permissible. Now, if they can make a mistake, they could, but I wouldn't rely on the government's mistake to rely on it and work or get it. Most likely you will get a denial. We have been seeing when people are not in H4 status, the USCIS tends to deny those cases.
Got it. Okay, another update we had recently was USCIS, I believe they made it clear that the biometrics suspension is only for, not for all I-539, but it's only for H4, L2, E1, E2, and E3.
Correct.
Yeah, apart from that, there is a clause that I came across saying that, however, USCIS still retains the discretion on case-by-case basis to require biometrics for applicants who meet the criteria, and any applicant may be scheduled for an application support center appointment to submit biometrics. So that caught a lot of attention. A lot of people were saying, can USCIS still come and say that, yeah, H4 need a biometrics or L2 need biometrics?
So they are very worried about security. After September 11th of 2001, as most of you know, the entire immigration landscape in the United States changed, and they definitely want, the reason that the prior Trump administration set up the whole biometrics was to ensure that nobody's abusing or misusing the system, and that we have some type of a terrorist or somebody that has a problem situation. So the USCIS government always reserves the right to look into it. And in fact, even the whole thing about EADs is now becoming discretionary. People were shocked by that because they were like, what do you mean I need to do? Isn't that automatic? It is supposed to be, but now they have made it somewhat discretionary. And I was just talking to a lawyer. In fact, I was teaching immigration lawyers the updates and the latest of what's going on. And some of them were saying that they actually put big, long memos explaining, why the person should get the EAD. Now, we have never usually had a problem with that, and that there's not supposed to be discretion in the issuance of the EAD card. But technically, every decision of USCIS or Department of Homeland Security with respect to immigration benefits is ultimately discretionary. So anytime if they believe that somebody could pose a risk, security hazard to America or something, they absolutely can require such a person to go through the biometrics. They could deny the EAD potentially. They could delay it. They could issue RFEs, and they actually can completely deny it as well if they wish.
Yeah, another question is, Ms. Murthy, Department of State anyways collects biometrics every time you stamp a visa, or every time, at least the first time you enter the country, you anyways have to submit. And everyone knows Department of State, USCIS and CBP, they work hand in hand. Why don't they take the biometric data from there and, at least save a lot of time and money for everyone?
Yeah, it's kind of shocking. It's true that we have visa appointment interviews and we have the CBP. When you enter, we give our fingerprints and all of that, unless you're a citizen, for non-immigrants. So they should have all that, which is why it was never required all these years. The Trump administration tried to put as many hurdles, roadblocks to create hassles and problems for immigrants and people going through, especially non-immigrants coming into the United States, to purposefully delay. And this was a good way to try to delay H4 EADs, etc., because they wanted to eliminate it, but they couldn't. So they thought this is one way to harass people and to delay issuance of EAD cards. They should have it. You're right. They have the consulates have the fingerprinting. The CBP, when you enter the United States, has the fingerprinting. Everyone should have it. So I don't know why they're wasting time and money, but it sounds like it's a delaying tactic overall. And hopefully by postponing it now, at least for H4, L2, E1, E2, E3s, for 2 full years from May 17th of 2021 to May 17th of 2023, I'm hoping that is a precursor, like sometimes you do to buy time. It is a precursor to eliminate the rule altogether without looking like you are not bothered about security of the United States.
Thanks, Ms. Murthy. Thanks for your time. We are at the end of the show. Thanks, everyone, for the calls and watching the show. It was a great session with interesting topics. Please call in every Tuesday at 3 p.m. EST to watch the special immigration show with Ms. Murthy and ask any question. Again, it's every Tuesday, 3 p.m. EST on Sakshi TV. This is Ranjit signing off. Thanks.
Thank you. Bye-bye.